Training and development should help companies achieve their business goals, resulting in profits and positive returns for stockholders. But stockholders only represent one stakeholder that invests in an organization's success. Other important stakeholders include local community and employees who want to benefit from training and development. Social responsibility also means that companies need to comply with laws and regulations, but perhaps more importantly, take actions and create conditions that help employees grow, develop, contribute to company goals, regardless of their background and career issues they're facing. So let's take a look at 9 legal and social issues in training and development. Here are some potential training activities and situations that can make an employer vulnerable to legal actions and harm the company's social reputation. Failing to provide training or providing inaccurate training. To comply with a wide range of laws and regulations, companies are required to show that employees not only have completed training programs, but also are applying their new knowledge to the job. Most companies provide training to reduce potential for hostile work environment for employees protected under Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, or the Americans with Disabilities Act. Incurring employee injury during a training activity. On-the-job training and simulations often involve the use of work tools and equipment that could cause injury if incorrectly used. Workers' compensation laws in many states make employers responsible for paying employees their salary and providing them with a financial settlement for injuries received during any employment-related activity, such as training. Managers should ensure that 1. Employees are warned of potential dangers of incorrect use of equipment, and 2. Safety equipment is used. Incurring breach of confidentiality or defamation. Managers should ensure that information placed in employees' files regarding performance and training activities is accurate. Also, before discussing employees' performance and training with other employees or using training performance information for promotion or salary decisions, managers should tell employees that training performance will be used in that manner. In training, we need to be cautious of copyrights that protect the expression of an idea, like a training manual for a software program. Copyrights also prohibit others from creating a product based on the original work and from copying, broadcasting, or publishing the product without permission. Excluding women, minorities, and older employees from training programs. 2 pieces of legislation make it illegal for employers to exclude women, minorities, or older persons from training programs. Title VII of the Civil Rights Act, amended in 1991, makes it illegal to deny access to employment or deprive a person employment because of that person's race, color, religion, gender, or national origin. The Age Discrimination in Employment Act prohibits discrimination against persons who are age 40 or older. The Equal Employment Opportunity Commission, or EEOC, is responsible for enforcing both the Civil Rights Act and the ADEA. Not ensuring equal treatment of all employees while in training. Equal treatment of all trainees means that conditions of the learning environment are available for all trainees regardless of their background. Also, trainers should avoid jokes, stories, and props that might create a hostile learning environment. Requiring employees to attend programs that might be offensive. Allstate Insurance has been the focus of several religious discrimination lawsuits brought by insurance agents. Some agents charged that the principles emphasized in training programs were based on Scientology, were offensive to counter other religious beliefs. For example, the training program taught concepts such as the tone scale, which catalogs emotions and Scientologists believe can influence behavior. Revealing discriminatory information during a training session. At Lucky Store Foods, a California supermarket chain, notes taken during a diversity training program were used as evidence of discrimination. In the training session, supervisors were asked to verbalize their stereotypes. Some comments, women cry more, or black women are more aggressive, were derogatory towards women and minorities. The plaintiff in the case used the notes as evidence that the company conducted the training session to avoid an investigation by the EEOC. The case was settled out of court. And finally, accommodating trainees with disabilities. The Americans with Disabilities Act, or ADA, of 1990, prohibits individuals with disabilities from being discriminated against in the workplace. The ADA prohibits discrimination based on disability in training.